The fastest way to lose a lawsuit is to assume you have authority you never actually had. That sentence kept echoing through my mind the morning I found a thick envelope taped to my front door. At first, I assumed it had been delivered to the wrong address. I lived on a quiet 5-acre property outside the Maple Creek subdivision, separated from the neighborhood by an old line of oak trees and a split-rail fence that had stood there long before I bought the place. I picked up the envelope, glanced at the return address, and immediately noticed the name of the Maple Creek Homeowners Association. Inside was a formal lawsuit demanding that I remove a wooden privacy fence because it supposedly violated community architectural standards. I read the first page twice, then a third time, wondering if I had somehow missed something during the purchase of my property 3 years earlier. According to the complaint, I was a member of the Homeowners Association, subject to its rules, and had refused multiple requests to comply. The strange part was that none of those statements were true. Nobody had ever contacted me before. I had never attended a homeowners association meeting. I had never paid a single association fee. Most importantly, I had never agreed to join one. Instead of getting angry, I carried the paperwork into my kitchen, spread every document from my home purchase across the dining table, and started reading from the beginning. My closing file included the warranty deed, title insurance policy, county survey, settlement statement, and every disclosure signed on closing day. I spent nearly 3 hours comparing page after page. Nothing mentioned the Homeowners Association. Nothing referenced neighborhood covenants. Nothing suggested my property belonged to Maple Creek in any way. I called the title company that had handled my purchase, and the representative politely confirmed that their records also showed no active homeowners association attached to my parcel. That should have been the end of the story. But something continued bothering me. Why would an attorney file a lawsuit if the basic ownership records could be disproved in less than an afternoon? Curiosity replaced frustration. I drove to the county property records office and requested copies of the official parcel information. The clerk printed my deed history, tax parcel summary, and subdivision map without hesitation. As I compared the documents, one detail immediately stood out. My legal description placed my land outside the recorded Maple Creek subdivision, exactly as I expected. However, the county tax summary included a small administrative code identifying my parcel as associated with the Maple Creek Homeowners Association. I asked the clerk whether that code created legal membership. She shook her head and explained that tax reference codes and legal ownership records were not always the same thing. Even so, she admitted the combination looked unusual and suggested I request a full property history if I planned to challenge the lawsuit. Before leaving, I searched the county's online geographic mapping system from a public computer in the lobby. My property appeared highlighted with the subdivision, even though my recorded deed clearly placed it outside the neighborhood boundary. 2 official county records were already telling different stories about the same piece of land. As I walked back to my truck, my phone rang. The caller introduced himself as the attorney representing the Homeowners Association and calmly reminded me that the court had scheduled our preliminary hearing in exactly 10 days. Before ending the call, he said something that made me stop in the middle of the parking lot. According to the Homeowners Association's membership database, I had been listed as a homeowner inside Maple Creek for nearly 15 years, almost 12 years before I had ever purchased the property. The next morning I decided that assumptions had already caused enough problems, so every answer from that point forward would have to come from official records instead of opinions. The preliminary hearing was now only 9 days away, and I wanted to understand why 4 different sources seemed to describe the same property in 4 different ways. My first stop was the title company that had handled my closing 3 years earlier. The senior examiner welcomed me into a conference room, spread my complete closing file across the table, and reviewed every recorded document from the original purchase. She pointed to the warranty deed, the title commitment, the owner's title insurance policy, and the final title opinion. Every one of them confirmed exactly the same legal description. My 5-acre parcel was an independent tract that bordered Maple Creek but was never included inside the recorded subdivision. She looked at me and quietly admitted that if an active homeowners association covenant had existed, their office would have been legally required to disclose it before closing. No such covenant appeared anywhere in the chain of title. Before I left, she said something that caught my attention. In more than 20 years of reviewing real estate transactions, she had never seen a lawsuit filed over an alleged homeowners association membership without a corresponding recorded covenant. That statement only deepened the mystery. From there I drove to the County Geographic Information Systems office. An analyst pulled my parcel onto a large monitor and overlaid several mapping layers dating back more than 20 years. The newest planning layer showed my property touching the subdivision exactly as the Homeowners Association claimed. Then he switched to the official cadastral layer used for legal property boundaries. My parcel immediately separated from Maple Creek by a narrow strip identified as an independent recorded tract. The analyst explained that planning maps were often created for administrative convenience, while the cadastral map reflected legally recorded ownership. I asked why both systems disagreed. He admitted he could not answer without reviewing older archived revisions because someone had updated the planning layer years earlier. Before leaving, he printed copies of both maps and encouraged me to compare them carefully. Later that afternoon I met with a licensed land surveyor named Thomas Bennett, who had worked throughout the county for decades. After examining both maps, he smiled politely and unfolded a much older subdivision survey recorded before Maple Creek had even been built. The original drawing clearly showed my parcel sitting outside the planned development boundary. Even more surprising, the survey included handwritten revision notes indicating that the developer had once proposed expanding the subdivision to include my land before abandoning that idea. Thomas explained that developers often revised plans during construction, but only the officially recorded version controlled legal ownership. As I studied the faded survey, another question immediately surfaced. If the expansion had never been approved, how had my parcel ended up inside the Homeowners Association database for 15 years? That evening I returned home carrying a growing stack of certified copies, historical maps, and survey records. Instead of feeling overwhelmed, I felt strangely encouraged because every official legal document continued pointing in the same direction. Only administrative records seemed to tell a different story. Just before sunset my phone buzzed with a new electronic notice filed through the court system. The attorney representing the Homeowners Association had submitted a copy of their neighborhood membership roster as evidence. I opened the attachment expecting to see my own name somewhere near the bottom. Instead, I found something far more confusing. The roster listed my property address as belonging to the Homeowners Association nearly a decade before the house currently standing on my land had even been built. By the third morning, I realized the lawsuit had become far bigger than a disagreement over a fence. It had become a race to discover who had rewritten the history of my property before the court accepted someone else's version as fact. The preliminary hearing was now only 7 days away, and I spent the morning with Thomas Bennett walking every foot of my property carrying his original field notes, a metal detector for old survey monuments, and copies of the earliest recorded subdivision plans. One by one we located iron survey pins that had remained buried beneath the soil for decades. Every measurement matched the legal survey recorded with the county. My fence stood entirely inside my property by more than 30 feet at its closest point to Maple Creek. Thomas explained that survey monuments always carried greater legal weight than planning sketches or neighborhood maps because they represented the physical evidence placed on the land itself. That should have settled the dispute, yet the Homeowners Association database still insisted I belonged inside the community. While reviewing the oldest subdivision drawings, Thomas noticed something neither of us had recognized before. The developer's first concept plan showed my parcel outlined with a dotted line labeled Future Acquisition. A later revision crossed out that notation entirely, replacing it with handwritten words that read, Excluded from Final Plat. Thomas quietly explained that developers often hoped to purchase neighboring land before construction, but if negotiations failed, the final recorded subdivision simply moved forward without it. My property had apparently remained independent from the very beginning. That discovery answered one mystery but immediately created another. If the developer never acquired my land, who later decided to treat it as though it belonged to Maple Creek? After leaving Thomas, I drove to the county planning department and requested every publicly available record related to the original subdivision approval. A planning technician retrieved several archive folders containing engineering correspondence, utility approvals, and revised development maps. Most documents confirmed exactly what I had already learned. Then one memo caught my attention. Written several months before the subdivision received final approval, it referenced a revised entrance road after negotiations with the neighboring property owner had ended without an agreement. Although my parcel was never identified by name, the location matched my land perfectly. The technician explained that the county ultimately approved the revised entrance and the smaller subdivision exactly as recorded. There was no indication that my property had ever become subject to neighborhood restrictions. Before I left, she suggested requesting archived geographic information systems revisions because planning maps were sometimes updated years after construction for administrative purposes. That afternoon I returned home and compared every document across my dining room table. Deeds, surveys, planning memorandums, engineering drawings, tax records, and subdivision plats all pointed toward the same conclusion. Only one thing refused to fit. The Homeowners Association membership roster still listed my address as though it had always belonged inside Maple Creek. Just before dinner my email notification sounded again. This time it came from the Geographic Information Systems analyst I had met the previous day. He had begun reviewing historical revisions to the county planning layer and found something unexpected. The map showing my property inside the subdivision had not existed when Maple Creek was first approved. According to the revision history, someone added that boundary years later during a routine digital mapping update, and the archived record did not identify why the change had ever been made. By the fourth day, I stopped asking whether the Homeowners Association had made a mistake and started asking whether someone had ignored the truth on purpose. The preliminary hearing was only 5 days away, and I knew every hour mattered. Since the lawsuit mentioned several alleged violations and multiple enforcement notices that I had supposedly ignored, I filed a formal request through my attorney demanding copies of every Homeowners Association record connected to my property. If they believed I had been a member for 15 years, there had to be meeting minutes, approval requests, architectural reviews, payment records, or violation letters somewhere in their files. 2 days later, a digital folder arrived through the discovery process. I opened it expecting hundreds of pages. Instead, there were surprisingly few documents. The first file contained the neighborhood membership roster I had already seen. The second included photographs of my fence taken from the public road only weeks earlier. The third contained several warning letters addressed to me, but every one of them had been mailed to an address where I had never lived. The mailing history showed they had all been returned without delivery years before I even purchased the property. That immediately raised another question. If every notice had been returned, how could the Homeowners Association later claim I had intentionally ignored them? I kept reading. The board meeting minutes from the previous 3 years mentioned my property only once. According to the record, the president, Linda Marshall, announced that legal action would begin because repeated compliance efforts had failed. What surprised me was what the minutes did not contain. There had been no recorded vote authorizing the lawsuit. No discussion of legal authority. No review of my deed. No mention that anyone had verified whether my property actually belonged inside the association. Everything appeared to rest entirely on Linda's recommendation. My attorney immediately noticed the same thing and requested the association's internal correspondence regarding my parcel. Late that afternoon another production arrived. Buried among routine electronic messages was an email exchange from nearly 4 years earlier between a volunteer board member and the association's management company. The volunteer had questioned why my property appeared inside the membership system even though the county subdivision plat seemed to exclude it. The management company responded that they would investigate before any enforcement action should ever be taken. I searched the remaining messages looking for the follow-up report. It never appeared. Instead, the conversation simply ended. There was no explanation, no conclusion, and no evidence that anyone had completed the promised review. That missing report suddenly became more important than every other document I had collected. Either the investigation had confirmed my property did not belong in the association, or it had never been completed at all. Just before sunset, my attorney called after reviewing everything himself. He explained that the missing follow-up could become a critical issue because it suggested the board had been warned about uncertainty years before filing the lawsuit. He also shared another unexpected development. The law firm representing the Homeowners Association had contacted his office requesting additional copies of my closing documents instead of insisting their own records were correct. For the first time since this ordeal began, it sounded as though someone on the other side had started asking the same questions I had been asking all week. Then my attorney ended the call with news that changed the direction of the entire case. The judge had granted our request for limited additional discovery before the hearing, giving us one final opportunity to uncover the missing investigation that someone, somewhere, seemed determined to leave buried. 3 days before the hearing, I finally realized the case was no longer about proving that I was right. It was about proving that the Homeowners Association had ignored opportunities to discover the truth before dragging me into court. My attorney and I spent the morning organizing every certified record we had collected. We arranged the warranty deed, the original subdivision plat, the title insurance policy, the historical surveys, the planning memorandums, and the geographic information system's revision history into chronological order. When everything was laid across the conference table, the story became surprisingly clear. Every legally recorded document agreed with every other legally recorded document. Only administrative databases and internal association records claimed my property belonged to Maple Creek. Around noon, the attorney representing the Homeowners Association sent an unexpected request asking for complete copies of my closing file, including documents they had never requested before. Instead of objecting, my attorney immediately forwarded every page. A few hours later he received a brief telephone call from opposing counsel. He could not discuss confidential conversations, but after hanging up he smiled for the first time all week. He explained that the attorney on the other side appeared genuinely surprised by what the title documents contained. That reaction told me something important. Either the law firm had never been given my actual property records before filing the lawsuit, or someone had convinced them those records would support the association's claims. Late that afternoon we received another discovery production from the Homeowners Association. Hidden inside hundreds of routine emails was a document that almost escaped our attention. It was a draft memorandum prepared several years earlier by the association's outside management company. The unfinished report summarized concerns raised by a volunteer board member who questioned whether several neighboring parcels, including mine, had been entered into the membership database without confirming the recorded subdivision boundaries. The final page was missing, but one sentence remained visible near the bottom. It recommended verifying county recording information before pursuing enforcement against any affected property owners. There was no evidence that recommendation had ever been followed. My attorney immediately requested the complete memorandum, but the association responded that no additional copy could be located. That answer only increased our concern because electronic management companies rarely lost final reports. Someone had either failed to preserve an important document, or decided it was no longer convenient to produce it. The hearing was now only 2 days away, and the judge had ordered both parties to exchange every exhibit before appearing in court. As we prepared our evidence binder, my attorney pointed to one issue that could change everything. Until now, everyone had been arguing about fences, maps, and neighborhood rules. He believed the judge would focus on a much simpler question. Before discussing any alleged violation, the court first had to determine whether the Homeowners Association possessed legal authority over my property at all. If they could not establish that single point, every other argument would become irrelevant. Just before I left his office, my phone vibrated with a new email from the Geographic Information Systems analyst. He had completed the archive search I requested. During a routine digital conversion many years earlier, someone had manually reassigned my parcel to the subdivision planning layer without attaching any supporting deed, recorded plat, or legal authorization. The revision log identified the date of the change, but the field explaining why the edit had been made was completely blank. At that moment I understood that the courtroom battle would no longer revolve around my fence. It would revolve around a single unanswered question that nobody on the Homeowners Association seemed prepared to explain. The morning of the preliminary hearing arrived with a calm I had not expected. After a week of collecting deeds, surveys, archived maps, and forgotten records, I realized that none of it would matter unless the court answered one question before anything else. Did the Homeowners Association have legal authority over my property? My attorney reminded me not to volunteer unnecessary information. He said the strongest cases were often the simplest ones because they forced the other side to prove the one fact they had assumed all along. As we entered the courthouse, I noticed Linda Marshall sitting with the association's attorney reviewing a binder filled with photographs of my fence, copies of neighborhood rules, and violation notices. They looked prepared to argue about paint colors, fence height, and architectural standards. My attorney quietly leaned toward me and whispered that none of those documents mattered if they could not first establish jurisdiction. When the judge entered, both sides introduced themselves, and the hearing began exactly on schedule. The attorney representing the Homeowners Association confidently described my fence as an ongoing violation that ignored repeated enforcement efforts. He referenced community standards, neighborhood appearance, and board authority. The judge listened patiently without interrupting. Then she asked a single question that immediately changed the direction of the hearing. She asked counsel to identify the recorded document that legally subjected my property to the Homeowners Association. The courtroom became noticeably quieter. The attorney opened his binder, flipped through several sections, and presented the neighborhood membership roster along with the planning map that included my parcel. My attorney stood and handed the judge certified copies of my warranty deed, the recorded subdivision plat, the title insurance policy, and the historical survey establishing that my land had always remained outside the final recorded subdivision. The judge spent several minutes comparing both sets of documents without saying a word. She then turned back to the attorney for the Homeowners Association and asked whether he possessed any recorded covenant, deed restriction, annexation agreement, or signed membership document connecting my parcel to the association. After another long pause, he admitted that he did not have such a document available that morning. Instead, he argued that the association had treated my property as part of the neighborhood for many years and had relied upon county mapping information. The judge nodded politely but explained that administrative practice could not replace recorded legal authority. She asked whether anyone had investigated the discrepancy before filing the lawsuit. That question caught everyone off guard. My attorney immediately introduced the incomplete management company memorandum recommending verification of county records before enforcement. He also presented the Geographic Information Systems revision history showing that someone had manually reassigned my parcel during a digital update without citing any supporting legal document. Linda looked genuinely surprised as those exhibits appeared on the courtroom screen. For the first time since this dispute began, it seemed possible that even she had never seen some of the records now sitting before the judge. Rather than ruling immediately, the judge announced that the court required one final piece of evidence before deciding whether the case could proceed. She ordered the county recorder to produce the complete chain of recorded property documents, and directed both parties to return for the continued hearing 2 days later. As everyone gathered their files, the attorney representing the Homeowners Association quietly approached my attorney and admitted that if the county records confirmed our position, the entire foundation of the lawsuit could disappear before the court ever discussed the fence itself. When we returned to court 2 days later, the atmosphere felt completely different. The argument was no longer centered on my fence or neighborhood rules. Everyone in the courtroom understood that the case now depended on a single chain of recorded documents that had existed long before either Linda Marshall or I had ever heard of Maple Creek. The county recorder arrived carrying several certified archive books along with digitally scanned copies of every recorded instrument affecting my property. After being sworn in, she carefully explained how subdivision boundaries became legally enforceable. Proposed development plans, marketing brochures, planning maps, and internal databases could all change over time, but only documents officially recorded with the county established legal property rights. She then walked the court through the timeline one document at a time. The original developer had submitted an early concept plan showing my parcel as a possible future expansion. Several months later, after negotiations with the neighboring landowner failed, the developer filed a revised final plat that permanently excluded my tract before the subdivision was ever approved. The recorder displayed both documents side by side on the courtroom screen. The difference was impossible to miss. The dotted outline surrounding my land had disappeared completely from the final recorded version. My attorney then introduced another certified record that none of us had previously seen. While preparing for the hearing, the county archives had located a receipt confirming that the revised plat replacing the original proposal had been properly recorded and distributed to every department responsible for maintaining subdivision records. That meant the planning office, tax office, and future mapping staff had all received notice that my property remained outside Maple Creek. The judge carefully examined the receipt before asking the recorder whether any later recorded document had ever added my parcel back into the Homeowners Association. The answer came without hesitation. No recorded annexation, amendment, covenant, easement, deed restriction, or supplemental declaration had ever been filed affecting my land. My attorney quietly thanked the recorder before introducing one final exhibit obtained from the developer's archived correspondence. Years before construction began, the developer's attorney had written a letter explaining that the neighboring parcel could not be included because the owner declined to sell. Rather than delaying the project, the developer chose to redesign the entrance road and proceed without acquiring the property. As I listened, I realized that every mystery we had uncovered during the previous week suddenly fit together. The planning maps had eventually changed. Administrative databases had eventually changed. The Homeowners Association membership system had eventually changed. The only thing that had never changed was the recorded legal history of my property. Linda appeared genuinely unsettled as she quietly reviewed the newly admitted exhibits with her attorney. Even he seemed surprised by the developer's correspondence and the county distribution receipt. The judge then turned toward the Homeowners Association's counsel one final time and asked whether he possessed any evidence showing that the recorded legal history presented by the county had ever been superseded. After several moments of silence, he acknowledged that he could not produce such evidence. Instead, he admitted that the association had relied on administrative records it believed were accurate. The judge thanked both sides for their presentations and announced that the legal issue of authority had now been fully developed. She would review the complete record before issuing her decision. As the hearing concluded, my attorney quietly leaned toward me and said that for the first time since this lawsuit began, the question was no longer whether we could prove the truth. The only remaining question was how the court would respond after concluding that the Homeowners Association had never possessed legal authority over my property in the first place. The written ruling was scheduled for the following morning, and even though the evidence had consistently supported my position, I knew better than to celebrate before the judge spoke. My attorney reminded me that courts followed the law, not expectations. We arrived early and quietly took our seats while the courtroom gradually filled. Linda Marshall sat across the aisle with the association's attorney. Neither of them appeared angry. They simply looked exhausted after watching a straightforward fence dispute transform into a legal examination of authority that reached back decades before either of us became involved. When the judge entered, she began by thanking both parties for presenting a thorough record. She explained that before any court could consider whether a homeowner violated neighborhood restrictions, it first had to determine whether those restrictions legally applied to that homeowner. Everything else depended upon that single foundation. She then summarized the evidence in careful chronological order. The original development proposal had once considered including my property, but the officially recorded final subdivision permanently excluded it. Every subsequent deed transferring ownership of my land described the same independent tract. No recorded declaration, amendment, annexation, covenant, or agreement had ever subjected my parcel to the Maple Creek Homeowners Association. The judge acknowledged that administrative records, planning maps, and internal databases had incorrectly identified my property for many years, but she explained that administrative errors could not create legal obligations where none existed. She then addressed the issue that had quietly grown more significant throughout the proceedings. The Homeowners Association had received at least one internal warning questioning whether my parcel actually belonged inside the association, yet no evidence showed that concern had ever been resolved before legal action began. The judge emphasized that responsible governance required verification when credible questions arose, especially before filing a lawsuit against the property owner. She looked toward the association's attorney and stated that the court found no legal basis establishing jurisdiction over my property. Because the Homeowners Association lacked authority to regulate my land, every enforcement action flowing from that mistaken assumption failed as a matter of law. She granted my motion, dismissed the lawsuit, and ordered that all claims relating to my fence be denied. For a brief moment, the courtroom became completely silent. The argument that had consumed weeks of investigation disappeared in a few carefully chosen sentences because the legal foundation had never existed. I felt relief, but more than that, I felt gratitude that the decision rested on facts rather than emotion. My attorney thanked the court, believing the matter had ended. Then the judge continued speaking. She explained that the record also raised serious concerns regarding unnecessary litigation expenses created by the failure to verify public records before initiating the lawsuit. Rather than deciding attorney fees immediately, she scheduled an additional hearing allowing both parties to submit written arguments addressing whether the Homeowners Association should reimburse the legal costs I had been forced to incur. That announcement visibly changed the atmosphere once again. The case was no longer about whether I could keep my fence. That issue had been resolved. Now the court would determine whether the financial consequences of the association's actions should remain with me or shift back to the organization that had brought the lawsuit. As we walked out of the courtroom, my attorney quietly smiled and said the legal battle over authority was finished, but the court had just opened an entirely new chapter that could ultimately require the Homeowners Association to accept responsibility not only for its mistake, but also for the cost of making me prove it. The final hearing lasted less than 30 minutes, but it brought an ending that felt far bigger than I ever expected when this entire ordeal began with a single envelope taped to my front door. The judge explained that after reviewing the written submissions from both parties, the court found that the Homeowners Association had pursued litigation without first confirming the most basic legal requirement, whether my property actually fell within its authority. She noted that the public records establishing my parcel's independent status had always been available through ordinary investigation and that multiple opportunities had existed to resolve the discrepancy before anyone stepped inside a courtroom. Because those opportunities had been overlooked, the court concluded that I should not bear the financial burden of defending a lawsuit that lacked a legal foundation from the beginning. The judge ordered the Homeowners Association to reimburse a substantial portion of my reasonable attorney fees and court costs. She also directed that certified copies of the ruling be provided to the county offices responsible for maintaining property mapping information so that the administrative records could finally match the recorded legal documents. The ruling did not accuse anyone of acting with malicious intent. Instead, it emphasized something much more important. Good governance depended upon verifying facts before exercising authority. After the hearing ended, Linda Marshall approached my attorney and me in the courthouse hallway. Her expression was very different from the confidence I had seen when this case first began. She admitted that she had trusted the association's records without questioning how they had been created and said the board would begin reviewing every property listed along the subdivision boundary. I appreciated the apology because it acknowledged the real problem. The issue had never been my fence. The issue had been assuming that a database could replace recorded law. During the following weeks, the county corrected its planning maps to match the recorded subdivision plat. The Homeowners Association updated its membership database and removed my property entirely. Several neighbors later introduced themselves and admitted they had always believed my land belonged inside Maple Creek because that was what every map seemed to show. Once they saw the recorded documents, they understood how easily an administrative error could survive for years simply because nobody stopped to question it. Life gradually returned to normal. My fence remained exactly where it had always stood, surrounding the same 5 peaceful acres I had purchased years earlier. Every time I walked along the property line, I noticed the old iron survey monuments that Thomas Bennett had helped uncover beneath the soil. Those markers had quietly told the truth for decades while computer systems, planning layers, and neighborhood records drifted farther away from reality. In the end, the oldest evidence turned out to be the most reliable. Looking back now, I realized that winning the case was never about defeating a homeowners association or embarrassing its president. It was about protecting a principle that affects every property owner. Authority must come from law, not assumption. Records must be verified before they are enforced. And sometimes the smallest question, asked at exactly the right moment by a patient judge, can expose an error that has been hiding in plain sight for years. My land never changed. The fence never moved. The only thing that finally changed was the paperwork, and once the records reflected the truth again, the dispute that had seemed so overwhelming simply disappeared, leaving behind a lesson I will never forget about the difference between believing you have power and actually having it.